Title 11, Crimes Against Chastity. 1. Art 333, Adultery. 2. Art 334, Concubinage. 3. Art 336, Acts of Lasciviousness. 4. Art 337, Qualified Seduction. 5. Art 338, Simple Seduction. 6. Art 339, Acts of Lasciviousness with the consent of the offended party. 7. Art 340, Corruption of minors. 8. Art 341, White slave trade. 9. Art 342, Forcible abduction. 10. Art 343, Consented abduction. 11. Art 344, Prosecution of the crimes of adultery. 12. Art 345, Civil liability. 13. Art 346, Liability of ascendants, guardians, teachers, or other persons entrusted with custody of the offended party. Article 333 Adultery elements. 1. The woman is married. 2. She has sexual intercourse with a man not her husband. 3. As regards the man with whom she has sexual intercourse, he knows her to be married. Legends. H. Husband. W. Wife. M. Marriage offenders. Married woman and/or the man who has carnal knowledge of her, knowing her to be married, even if the M be subsequently declared void. It is not necessary that there be a valid M, i.e. void ab initio, essence of adultery, violation of the marital vow. Gist of the crime: the danger of introducing spurious heirs into the family, where the rights of the real heirs may be impaired and a man may be charged with the maintenance of a family not his own. USV Mota. The offended party must be legally married to the offender at the time of the filing of the complaint, even if the marriage be subsequently declared void. Each sexual intercourse constitutes a crime of adultery. Abandonment without justification is not exempting, but only mitigating. Both defendants are entitled to this mitigating circumstance. The man, to be guilty of adultery, must have knowledge of the married status of the woman. A married man who is not liable for adultery, because he did not know that the woman is married, may be held liable for concubinage. Acquittal of one of the defendants does not operate as a cause of acquittal of the other. Under the law, there is no accomplice in adultery. Direct proof of carnal knowledge is not necessary. Circumstantial evidence is sufficient, i.e. love letters signed by the paramour, photos showing intimate relations, testimony of witnesses. Pardon by the H does not exempt the adulteress W and her paramour from criminal liability for adulterous acts committed subsequent to such pardon, because the pardon refers to previous and not to subsequent adulterous acts. Effective pardon applies to concubinage as well. 1. The pardon must come before the institution of the criminal prosecution, and 2. Both the offenders must be pardoned by the offended party. Act of sexual intercourse subsequent to adulterous conduct is considered as an implied pardon. 3. Pardon of the offenders by the offended party is a bar to prosecution for adultery or concubinage. 4. Delay in the filing of complaint, if satisfactorily explained, does not indicate pardon. Effect of consent: the husband, knowing that his wife, after serving sentence for adultery, resumed living with her co-defendant, did nothing to interfere with their relations or to assert his rights as husband. The second charge of adultery should be dismissed because of consent. People v. Cincano and Ramos. Agreement to separate may be used as evidence to show consent by the husband to the infidelity of his wife. Effect of death of paramour: offending wife may still be prosecuted. The requirement that both offenders should be included in the complaint is absolute only when the two offenders are alive. Effect of death of offended party: the proceedings may continue. Art. 353 seeks to protect the honor and reputation not only of the living but of dead persons as well. B. Article 334 Concubinage elements. 1. The man is married. 2. He is either a. Keeping a mistress in the conjugal dwelling, b. Having sexual intercourse under scandalous circumstance with a woman not his wife, c. Cohabiting with her in any other place. 3. As regards the woman, she knows him to be married. Offenders: married man and the woman who knows him to be married. The woman only becomes liable if she knew him to be married prior to the commission of the crime. In the third way of committing the crime, mere cohabitation is sufficient. Proof of scandalous circumstance is not necessary. People v. Piddock et al. Notes. A married man is not liable for concubinage for mere sexual relations with a woman not his wife. A man would only be guilty of concubinage if he appeared to be guilty of any of the acts punished in Art. 334. A married man who is not liable for adultery because he did not know that the woman was married may be held liable for concubinage. If the woman knew that the man was married, she may be held liable for concubinage as well. Mistress: a woman taken by the accused to live with him in the conjugal dwelling as his mistress concubine. People v. Bacon and People v. Hileo. Keeping a mistress in the conjugal dwelling. No positive proof of sexual intercourse is necessary. Conjugal dwelling: the home of the husband, H, and the wife, W, even if the wife appears to be temporarily absent on any account. The dwelling of the spouses was constructed from the proceeds of the sale of their conjugal properties. The fact that W never had a chance to reside therein and that H used it with his mistress instead, does not detract from its nature. People v. Cordova, 1959. Cohabit: to dwell together as H and W for a period of time, i.e. a week, a month, year or longer. Scandalous circumstances: scandal consists in any reprehensible word or deed that offends public conscience, redounds to the detriment of the feelings of honest persons, and gives occasion to the neighbor's spiritual damage or ruin. People v. Santos: it is only when the mistress is kept elsewhere outside the conjugal dwelling that scandalous circumstances become an element of the crime. US v. Macabag. Qualifying expression: sexual act which may be proved by circumstantial evidence. Scandal produced by the concubinage of H. 1. H and mistress live in the same room of a house. 2. They appear together in public. 3. Perform acts in sight of the community which give rise to criticism and general protest among the neighbors. When spies are employed for the purpose of watching the conduct of the accused and it appearing that none of the people living in the vicinity has observed any suspicious conduct, there is no evidence of scandalous circumstances. US v. Campos Rueda. Reason: adultery is punished more severely than concubinage because adultery makes possible the introduction of another man's offspring into the family so that the offended H may have another man's son bearing H's name and receiving support from him. See Article 336, Acts of Lasciviousness Elements. The offender commits any act of lasciviousness or lewdness. B. The act is committed against a person of either sex. C. It is done under any of the FF circumstances. 1. By using force or intimidation, or 2. When the offended party is deprived of reason or otherwise unconscious. 3. By means of fraudulent machination or grave abuse of authority. 4. When the offended party is under 12 years of age or is demented. Notes: lewd, obscene, lustful, indecent, lecherous, signifies form of immorality which has relation to moral impurity or that which is carried in wanton manner. Motive of lascivious acts is not important because the essence of lewdness is in the very act itself. Example: if the kissing etc. was done inside church, which is a public place, absence of lewd designs may be proven, and the crime is unjust vexation only. But if the kissing was done in the house of a woman when she was alone, the circumstances may prove the accused lewd designs. Note: absent any of the circumstances of rape under the third element, the crime is unjust vexation, e.g., touching of breast. Lascivious intent is implied from the nature of the act and the surrounding circumstances. Consider the act and the environment to distinguish between acts of lasciviousness and attempted rape. Desistance in the commission of attempted rape may constitute acts of lasciviousness. There is no attempted or frustrated act of lasciviousness. Acts of lasciviousness v. grave coercion. 1. Acts of lasciviousness. Compulsion or force is included in the constructive element of force. Whereas in grave coercion, compulsion or force is the very act constituting the offense of grave coercion. 2. Acts of lasciviousness must be accompanied by acts of lasciviousness or lewdness. While grave coercion, the moral compulsion amounting to intimidation is sufficient. Acts of lasciviousness v. attempted rape. 1. Same means of committing the crime. 1. Force, threat, or intimidation is employed, or 2. By means of fraudulent machination or grave abuse of authority, or 3. The offended party is deprived of reason or otherwise unconscious, or 4. Victim is under 12 years of age or is demented. 2. In both, offended party is a person of either sex. 3. The performance of acts of lascivious character in both. 4. In acts of lasciviousness, acts performed do not indicate that the accused was to lie the offended party. While in attempted rape, acts performed clearly indicate that the accused purpose was to lie the offended woman. 5. Lascivious acts are the final objective sought by the offender in acts of lasciviousness, while in attempted rape, lascivious acts are only the preparatory acts to the commission of rape. Abuses against chastity. Art. 245. V. Acts of lasciviousness. Art. 336. 1. Abuses against chastity, committed by a private individual, in most cases, whereas in acts of lasciviousness, committed by a public officer only. 2. Some act of lasciviousness should have been executed by the offender in abuses against chastity, whereas in acts of lasciviousness, mere immoral or indecent proposal made earnestly and persistently is sufficient. Notes: the accused followed the victim, held her, embraced her, tore her dress, and tried to touch her breast. When a complaint for acts of lasciviousness was filed against him, accused claimed that he had no intention of having sexual intercourse with her and that he did the acts only as revenge. The court found the accused guilty of frustrated acts of lasciviousness. He held that there is no frustrated crime against chastity which includes acts of lasciviousness, adultery, and rape. People v. Famular Cano. From the moment the offender performs all the elements necessary for the existence of the felony, he actually attains his purpose. Motive of revenge is of no consequence since the element of lewdness is in the very act itself. Example: compelling a girl to dance naked before a man is an act of lasciviousness, even if the dominant motive is revenge for her failure to pay a debt. 2 kinds of seduction. 1. Qualified seduction. Art. 337. 2. Simple seduction. Art. 338. Lascivious conduct under RA 7610. The elements of sexual abuse under Section 5b of RA 7610 that must be proven in addition to the elements of acts of lasciviousness are as follows. 1. The accused commits the act of sexual intercourse or lascivious conduct. 2. The said act is performed with a child exploited in prostitution or subjected to other sexual abuse. 3. The child, whether male or female, is below 18 years of age. Navarrete vs. People, 2007. Lascivious conduct is defined under Section 2H of the Rules and Regulations of RA 7610 as 1. The intentional touching, either directly or through clothing, of the genitalia, anus, groin, breast, inner thigh, or buttocks, or the introduction of any object into the genitalia, anus or mouth of any person. 2. Whether of the same or opposite sex. 3. With an intent to abuse, humiliate, harass, degrade, or arouse or gratify the sexual desire of any person. 4. Bestiality, masturbation, lascivious exhibition of the genitals or pubic area of a person. Comparison with Art 366. RPC acts of lasciviousness is punished under RA 7610 when performed on a child below 18 years of age exploited in prostitution or subjected to other sexual abuse. Notes: the sweetheart theory applies in acts of lasciviousness and rape, felonies committed against or without the consent of the victim. It operates on the theory that the sexual act was consensual. It requires proof that the accused and the victim were lovers and that she consented to the sexual relations. For purposes of sexual intercourse and lascivious conduct in child abuse cases under RA 7610, the sweetheart defense is unacceptable. A child exploited in prostitution or subjected to other sexual abuse cannot validly give consent to sexual intercourse with another person. Malto v. People, 2007. D. Article 337. Qualified seduction. Seduction, enticing a woman to unlawful sexual intercourse by promise of marriage or other means of persuasion without use of force. It applies when there is abuse of authority. Qualified seduction, or deceit, simple seduction. Two classes of qualified seduction and their elements. 1. Seduction of a virgin over 12 years and under 18 years of age by certain persons such as a person in authority, priest, teacher, or any person who, in any capacity, shall be entrusted with the education or custody of the woman seduced. Elements: offended party is a virgin, which is presumed if she is unmarried and of good reputation. B. She is over 12 and under 18 years of age. 17 years 11 months 29 days. C. Offender has sexual intercourse with her. D. There is abuse of authority, confidence, or relationship on the part of the offender. 2. Seduction of a sister by her brother, or descendant by her ascendant, regardless of her age or reputation. Elements: offended party need not be a virgin or she may be over 18 years old. B. Offender has sexual intercourse with her. C. Offender is her brother or ascendant by consanguinity, whether legitimate or illegitimate. Notes: virgin, a woman of chaste character and of good reputation. The offended party need not be physically a virgin. If there is no sexual intercourse and only acts of lewdness are performed, the crime is acts of lasciviousness. If any of the circumstances in the crime of rape is present, the crime is not to be punished under Art 337. The accused charged with rape cannot be convicted of qualified seduction under the same information. Offenders in qualified seduction. 1. Those who abuse their authority. Person in public authority. B. Guardian. C. Teacher. 2. Person who, in any capacity, is entrusted with the education or custody of the woman seduced. A. Those who abused confidence reposed in them. B. Priest. C. House servant. D. Domestic. 3. Those who abused their relationship. Brother who seduced his sister. B. Ascendant who seduced his descendant. Notes: domestic, a person usually living under the same roof, pertaining to the same house. Not necessary that the offender be the teacher of the offended party. It is sufficient that he is a teacher in the same school. Qualified seduction may also be committed by a master to his servant, or a head of the family to any of its members. Qualified seduction of a sister or descendant, also known as incest, is punished by a penalty next higher in degree. The age, reputation, or virginity of the sister or descendant is irrelevant. The relationship need not be legitimate. Notes: a 15-year-old virgin, who was brought by her mother to the house of the accused and his wife to serve as a helper, repeatedly yielded to the carnal desires of the accused. As she was induced by his promises of marriage and frightened by his acts of intimidation. Held, deceit, although an essential element of ordinary or simple seduction, does not need to be proved or established in a charge of qualified seduction. It is replaced by abuse of confidence. People v. Fontanilla. Notes: the accused, a policeman, brought a 13-year-old girl with low mentality to the ABC hall where he succeeded in having sexual intercourse with her. The complaint did not allege that the girl was a virgin. The accused was charged with rape but convicted of qualified seduction. Held, though it is true that virginity is presumed if the girl is over 12 but under 18, unmarried and of good reputation, virginity is still an essential element of the crime of qualified seduction and must be alleged in the complaint. Accused is guilty of rape, considering the victim's age, mental abnormality and deficiency. There was also intimidation with the accused wearing his uniform. Babanto v. Zosa. Notes: Paris succeeded in having sexual intercourse with Mendoza after he promised to marry her. As he did not make good on said promise, Mendoza filed a complaint for consented abduction. Trial court found that the acts constituted seduction, acquitting him on the charge of consented abduction. Mendoza then filed a complaint for qualified seduction. Paris moved to dismiss the case on the grounds of double jeopardy. Held, there are similar elements between consented abduction and qualified seduction, namely, 1. The offended party is a virgin, and 2. Over 12 but under 18 years of age. However, an acquittal for consented abduction will not preclude the filing of a charge for qualified seduction because the elements of the two crimes are different. Paris v. CA. Note: the fact that the girl gave consent to the sexual intercourse is not a defense. Article 338. Simple seduction elements. Offended party is over 12 and under 18 years of age. B. She is of good reputation, single or widow. C. Offender has sexual intercourse with her. D. It is committed by means of deceit. Purpose of the law: to punish the seducer who by means of promise of marriage destroys the chastity of an unmarried female of previous chaste character. Notes: virginity of offended party is not essential. Good reputation is sufficient. Virginity of offended party is not required. Deceit generally takes the form of unfulfilled promise of marriage. Promise of marriage must be the inducement and the woman must yield because of the promise or other inducement. What about unfulfilled promise of material things, as when the woman agrees to sexual intercourse in exchange for jewelry? This is not seduction because she is a woman of loose morals. Promise of marriage after sexual intercourse does not constitute deceit. Promise of marriage by a married man is not a deceit if the woman knew him to be married. Seduction is not a continuing offense. F. Article 339. Acts of lasciviousness with the consent of the offended party elements. Offender commits acts of lasciviousness or lewdness. B. The acts are committed upon a woman who is a virgin or single or widow of good reputation, under 18 years of age but over 12 years, or a sister or descendant, regardless of her reputation or age. C. The offender accomplishes the acts by abuse of authority, confidence, relationship, or deceit. Notes: It is necessary that it be committed under circumstances which would make it qualified or simple seduction had there been sexual intercourse, instead of acts of lewdness only. When the victim is under 12 years, the penalty shall be 1 degree higher than that imposed by law. Sec 10 of RA 7610. Males cannot be the offended party. Notes: Acts of lasciviousness. Art 336 versus Acts of lasciviousness with consent. Art 339. 1. Acts of lasciviousness is committed under circumstances WC, had there been carnal knowledge, would amount to rape, while acts of lasciviousness with consent is committed under circumstances WC, had there been carnal knowledge, would amount to either qualified or simple seduction. 2. In acts of lasciviousness, offended party is a female or male, while in acts of lasciviousness with consent, offended party should only be female. G. Article 340. Corruption of minors. Elements. Offender promotes or facilitates the prostitution or corruption of persons underage, minors. B. Purposes to satisfy the lust of another. Habituality or abuse of authority or confidence is not necessary. Notes: It is not necessary that the unchaste acts shall have been done. Mere proposal will consummate the offense. The victim must be of good reputation, not a prostitute or corrupted person. H. Article 341. White slave trade. Acts punishable. 1. Engaging in business of prostitution. 2. Profiting by prostitution. 3. Enlisting the services of women for the purpose of prostitution. Note: Habituality is not a necessary element of white slave trade. Note: Under any pretext means one who engaged the services of a woman allegedly as a maid, but in reality for prostitution, is guilty under this article. Note: If a victim is under 12 years, penalty shall be 1 degree higher. Note: Offender need not be the owner of the house. Note: Maintainer or manager of house of ill repute need not be present therein at the time of raid or arrest. Corruption of minors versus white slave trade. 1. In corruption of minors, minority of the victim is essential, while in white slave trade, it is not required. 2. White slave trade only applies to females. Corruption of minors applies to both males and females. 3. White slave trade is generally for profit, while corruption of minors is not necessarily for profit. 4. White slave trade is committed habitually, whereas corruption of minors is committed by a single act. 2 kinds of abduction. 1. Forcible abduction. Art 342. 2. Consented abduction. Art 343. I. Article 342. Forcible abduction. Elements. The person abducted is any woman, regardless of her age, civil status or reputation. B. The abduction is against her will. C. The abduction is with lewd designs. Notes: Abduction, the taking away of a woman from her house or the place where she may be for the purpose of carrying her to another place with the intent to marry or to corrupt her. Notes: Crimes against chastity where age and reputation are immaterial. 1. Acts of lasciviousness against the will or without the consent of the offended party. 2. Qualified seduction of sister or descendant. 3. Forcible abduction is the taking away of the woman must be against her will. Notes: The taking away of the woman may be accomplished by means of deceit first and then by means of violence and intimidation. If the female abducted is under 12, the crime is forcible abduction, even if she voluntarily goes with her abductor. When the victim was abducted by the accused without lewd designs, but for the purpose of lending her to illicit intercourse with others, the crime is not abduction but corruption of minors. Rape may absorb forcible abduction, if the main objective was to rape the victim. Sexual intercourse is not necessary in forcible abduction. Lewd designs may be shown by the conduct of the accused. When there are several defendants, it is enough that one of them had lewd designs. Husband is not liable for abduction of his wife, as lewd design is wanting. Attempt to rape is absorbed in the crime of forcible abduction. Thus there is no complex crime of forcible abduction with attempted rape. Note: nature of the crime. The act of the offender is violative of the individual liberty of the abducted, her honor and reputation, and public order. Note: abduction is characterized by lewd design in forcible abduction, whereas in grave coercion, there is no lewd design, provided that there is no deprivation of liberty for an appreciable length of time. Note: in forcible abduction, purpose is to effect his lewd designs on the victim, while in corruption of minors, purpose is to lend the victim to illicit intercourse with others. Note: in forcible abduction, there is deprivation of liberty and lewd designs, while in serious illegal detention, there is deprivation of liberty and no lewd designs. Note: in forcible abduction with rape, 1. The violent taking of the woman is motivated by lewd designs, and 2. Crime against chastity. Whereas kidnapping with rape is 1. Not so motivated, and 2. A crime against liberty. Note: forcible abduction with rape, a complex crime under Art 48, and not a special complex crime. J. Article 343, consented abduction. Elements: A. Offended party is a virgin. B. She is over 12 and under 18 years of age. C. Offender takes her away with her consent, after solicitation or cajolery from the offender. D. The taking away is with lewd designs. Notes: purpose of the law: not to punish the wrong done to the girl because she consents to it, but to prescribe punishment for the disgrace to her family and the alarm caused by the disappearance of one who is, by her age and sex, susceptible to cajolery and deceit. Notes: if the virgin is under 12 or is deprived of reason, the crime is forcible abduction because such is incapable of giving a valid consent. The taking away of the girl need not be with some character of permanence. Offended party need not be taken from her house. When there was no solicitation or cajolery and no deceit and the girl voluntarily went with the man, there is no crime committed even if they had sexual intercourse. K. Article 344. Prosecution of private offenses. 1. Adultery. 2. Concubinage. 3. Seduction. 4. Abduction. 5. Acts of lasciviousness. Note: nature of the complaint. The complaint must be filed in court, not with the fiscal in case of complex crimes, where one of the component offenses is a public crime. The criminal prosecution may be instituted by the fiscal. The court motu proprio can dismiss the case for failure of the aggrieved party to file the proper complaint even if the accused never raised the question on appeal. Crimes against chastity cannot be prosecuted de officio. Note: adultery and concubinage. Who may file the complaint? Adultery and concubinage must be prosecuted upon complaint signed by the offended spouse. Note: the offended party cannot institute criminal prosecution without including both the guilty parties if they are alive. Both parties must be included in the complaint even if one of them is not guilty. Consent and pardon bar the filing of a criminal complaint. The imputation of a crime of prostitution against a woman can be prosecuted de officio, but crimes against chastity cannot. Prosecution of rape may be made upon complaint by any person. Note: effective pardon. 1. Effective pardon in adultery applies also to concubinage. 2. Condonation or forgiveness of one act of adultery or concubinage is not a bar to prosecution of similar acts that may be committed by the offender in the future. Consent. 1. May be express or implied. 2. given before the adultery or concubinage was committed. 3. Agreement to live separately may be evidence of consent. 4. Affidavit showing consent may be a basis for new trial. Notes: seduction, abduction, acts of lasciviousness, seduction, abduction, or acts of lasciviousness must be prosecuted upon complaint signed by 1. Offended party. When the offended party is a minor, her parents may file the complaint. 2. When the offended party is of age and is in complete possession of her mental and physical faculties, she alone can file the complaint. 3. Parents, grandparents, or guardian in that order. When the offended is a minor or incapacitated and refuses to file the complaint, any of the persons mentioned could file. The term guardian refers to legal guardian. He must be legally appointed by the court. The state may also file the complaint as parens patriae when the offended party dies or becomes incapacitated before she could file the complaint and has no known parents, grandparents, or guardians. Notes: effective pardon. 1. Offended party cannot institute criminal proceedings if the offender has been expressly pardoned by the offended party, or her parents, grandparents, or guardian. 2. Pardon by the parent, grandparent, or guardian must be accompanied by the express pardon of the offended woman. 3. The right to file action of the parents, grandparents, and guardian shall be exclusive of other persons and shall be exercised successively in the order provided. 4. Pardon by the offended party who is a minor must have the concurrence of parents, except when the offended party has no parents. Note: rape complexed with another crime against chastity need not be signed by the offended woman, since rape is a public crime. When the evidence fails to prove a complex crime of rape with another crime, and there is no complaint signed by the offended woman, the accused cannot be convicted of rape. Note: marriage of the offender with the offended party in seduction, abduction, acts of lasciviousness, and rape extinguishes criminal action or omits the penalty already imposed. Marriage, in cases of seduction, abduction, and acts of lasciviousness, extinguishes the criminal action even as to co-principals, accomplices, and accessories. Marriage must be entered into in good faith. Marriage may take place after criminal proceedings have commenced, or even after conviction extinguishes criminal action and remits penalty. L. Article 345. Civil liability of persons guilty of crimes against chastity. Those guilty of rape, seduction, or abduction. 1. Indemnify the offended woman. 2. Acknowledge the offspring, unless the law should prevent him from doing so. 3. In every case to support the offspring, except in cases of adultery and concubinage. B. Where either of the offended party or accused is married. C. When paternity cannot be determined, such as in multiple rape. D. Other instances where the law prevents such. Note: the adulterer and the concubine can be sentenced only to indemnify for damages caused to the offended spouse. Acknowledgement of offspring is not legally possible, because only children born of parents who could marry at the time of conception may be acknowledged. Support of the offspring is also not included, because the person who gives birth is one of the offenders. Note: in rape of a married woman, only indemnity is allowed. M. Article 346. Liability of ascendants, guardians, teachers, and other persons entrusted with the custody of the offended party. 1. Persons who cooperate as accomplices but are punished as principals in rape, seduction, abduction, etc. A. Ascendants. B. Guardians. C. Curators. D. Teachers. And 2. Any other person who cooperate as accomplice with abuse of authority or confidential relationship. 3. The teachers or persons entrusted with education and guidance of the youth shall also be penalized with disqualification. 4. Any person falling within the terms of this article, and any other person guilty of corruption of minors for the benefit of another, shall be punished by special disqualification from filling the office of guardian. NRA 7877 Anti-Sexual Harassment ACT Work. Education or training related. Sexual harassment defined work. Education or training related sexual harassment is committed by an employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any other person who, having authority, influence or moral ascendancy over another in a work or training or education environment, demands, requests or otherwise requires any sexual favor from the other, regardless of whether the demand, request or requirement for submission is accepted by the object of said act. Sec 3 RA 7877. Note: Work-related environment 1. The sexual favor is made as a condition in the hiring or in the employment, re-employment or continued employment of said individual, or in granting said individual favorable compensation, terms of conditions, promotions, or privileges, or the refusal to grant this sexual favor results in limiting, segregating or classifying the employee which in any way would discriminate, deprive or diminish employment opportunities or otherwise adversely affect said employee. 2. The above acts would impair the employee's rights or privileges under existing labor laws. Or 3. The above acts would result in an intimidating, hostile, or offensive environment for the employee. Sec 3 RA 7877. Note: Education or training environment. 1. Against one who is under the care, custody, or supervision of the offender. 2. Against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. 3. When the sexual favor is made a condition to the giving of a passing grade, or the granting of honors and scholarships, or the payment of a stipend, allowance, or other benefits, privileges, or consideration. Or 4. When the sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice. Sec 3 RA 7877. Note: Other persons liable. Any person who directs or induces another to commit any act of sexual harassment is herein defined, or who cooperates in the commission thereof by another without which it would not have been committed, shall also be held liable under this act. Sec 3 RA 7877. Note: Penalties. Any person who violates the provisions of this act shall, upon conviction, be penalized by imprisonment of not less than 1 month nor more than 6 months, or a fine of not less than 10,000 pesos, p. 10,000, or more than 20,000 pesos, p. 20,000, or both such fine and imprisonment at the discretion of the court. Sec 7 RA 7877. Note: Prescription. Any action arising from the violation of the provisions of this act shall prescribe in 3 years. Sec 3 RA 7877.